Okay, it is 6:30. I'd like to call this Wright Township Board of Supervisors public hearing to order. Please rise for the
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thanks everyone for coming out this evening. Appreciate it. And so the purpose of this hearing is to receive public comments and answer any questions regarding the proposed amendments to Chapter 320 Subdivision Land Development Ordinance and Chapter 360 Zoning Ordinance in accordance with the State Municipality Planning Code, or the MPC, and pursuant to public notice in the September 7th and the September 14th, 2023 editions of the Duncannon Record. Proof of publication for this advertising is on file during the same time period through today. Electronic PDF copies of the drafts of the proposed ordinances in their entirety were posted on the Township's website. In accordance with the MPC, a public hearing must be held prior to enactment of a proposed SALDO or zoning ordinance. The Board of Supervisors will be considering possible enactment and take a vote upon enactment of the amended Chapters 320 and Chapter 360 at the board meeting immediately following this public hearing. The proposed amendments were submitted to the Wright Township Planning Commission, Perry County Planning Commission, the Wright Township Zoning Officer, and the Wright Township Solicitor for review and recommendation. Comments were provided and addressed.
Okay, there are, on the front table here, there are two exhibits. The first one is the proposed amendments. They are marked there in this notebook, and you're welcome to come up and look at it, but like we said, they were on the website and it was advertised, and copies were actually provided to the Duncannon Record if anybody contacted them. Also, proof of publication is on file, and also from the newspaper, and we also have a certificate of service of public notice from our Township Solicitor, Michael Pykosh. And it said that they certify that the notice of public hearing relative to the zoning ordinance amendment and SALDO amendment appeared in the Newport Sun, the Duncannon Record newspapers of general circulation in Wright Township, Perry County on September 6th, September 7th, September 13th, and September 14th, as evidenced by the proof of publication affidavit attached here to and marked as Exhibit 1. So that'll be Exhibit 1, and that'll be Exhibit 2. We just kind of had them backwards on the agenda. So that's a presentation of our exhibits.
Thank you, Daisy. So at this time, we're going to open the floor to public comments and questions. If you would please first state your name and address all comments to the board or to the solicitor. This time, do we have any comments, questions?
I have one, or well, I have multiple, but I'll start there. Did you want to start on the zoning or SALDO? Is there any preferred?
Yeah.
Okay, SALDO. Okay, I see there's revisions to the building setback line and the setback definitions. Revised definition, well, I guess the first thing is, what is the difference between building setback line and setback? Because the building setback line in the definition has parentheses setback to it.
Yeah, I recall that we discussed that. I don't recall the outline in front of me.
The pages are page 6 and 25.
Yeah. Okay. Yes, we can.
The setback actually speaks more to the front, whereas the building setback line actually includes side and rear yards where required. So, but basically it says the same thing.
Okay, the definitions just aren't the same, so that's what I was on. So one's the distance for the front. It seems like
Yeah.
the setback is the
That one,
distance for the front.
that one speaks more to the front than whereas the building setback actually includes verbiage for side and rear yards.
Okay. Then I guess the follow-up question to that, concerning the building setback line, is I see now it was revised to include wording for the distance between any enclosed structure and adjacent, and this is the new part, road, utility, stream, or stormwater easements / right-of-way, as well as the property boundary line. Or before it was just the right-of-way line. So I'm commenting that the revised definition now includes easements for road, utility, stream, and stormwater, not just the right-of-way or property boundary line. How much land does the township want to keep taking from people without paying owners for their lack of ability to use it? What if a utility line runs through the middle of your property and has an easement for that electric utility? Now you can't put a building within a certain distance from their easement line. If the easement holder needs additional area to control what was done around their easement, they should have taken more easement or compensated the owner for it. So that's my comment is you're now including easement lines and everything else as setback lines, which seems, you're requiring people to not be able to use their property even more restrictive than what was before, it seems like. Can somebody confirm that that's what it's saying, right? It doesn't specify certain easements or anything, it just says easements.
To that point, because I know I was at some of the planning commission meetings and this
Yeah.
went back and forth. This was a lengthy
Yeah.
discussion.
They added that. They did.
Yeah, I wasn't at any of the planning commission meetings. I mean, that's what it says, but I don't know if the
Their thinking was behind it.
thinking was.
It might coincide with front yard setbacks that were so restricted before that we couldn't put anything in the front yard, almost anything. And so this is trying to clarify that, but also keeping restrictions, even though it looks like you're giving more restrictions, you're actually giving more. And you really won't want anything in an easement.
Especially a stormwater.
Yeah, the whole.
Right, but this is saying you'd have to adhere to the building setbacks on your subdivision plan, right? And the setbacks would now not only be from the property line, but now it's from an easement line too.
I remember this discussion, I think this was relevant to that portion, where there was, if somebody has a large piece of land and they want to build something, and if their house sits way back, they want to build something closer in front of it. This was an attempt to help allow that, because currently it was restricted. That's my recollection.
How does that wording help though, is what I'm wondering. That wording now includes more things as building setback lines. That's what it seems like, you're including more things as things to be set back from.
Well, I guess maybe the thought is if there's a utility line, you don't want to build right on top of it. I mean, there needs to be some room.
And that's why they have a utility easement, and they should be taking the easement, the required amount that they need to utilize and maintain that, correct?
Yeah,
Typically.
well, typically, but
And then if they need
what's the
extra.
setback, anyway, it's not a large setback, right? Is it?
For what? Which yard?
Yeah, depends.
It differs.
Yeah, so,
Front yard was the concern.
Well, the front yard would,
But this concerns everything, not just accessory buildings, correct?
yeah, this would cover everything. But I guess the idea was, you know, if there's a utility, if there's a stream, you know, anything like that, that it would be set back from that, however many feet that, each one of the setbacks, requires, either a side or, you know, rear setback line. So, you know, those items are not disturbed and are able to be used, you know, like an easement. I guess I would think that that's what the idea.
And I can understand the thinking, but I'm just thinking that,
And
why
John,
would you not
to
need
your-
a
to
larger
your-
easement?
To your main point about this being more restrictive, until this is adopted, they were not allowed to build forward of the structure, the primary structure. And that was the complaint that was trying to be addressed, is to allow people to be able to do that, which they currently cannot. So if they can now go forward of the structure, but they have to, you know, be mindful of the easements,
Right.
that's not less restrictive.
But I'll put the alternative spin on it. Somebody that has their house to the front, but has easements in the back, now they're even more restricted that way. Right?
On the subdivision plans, they usually pull them in anyway, pull the setbacks in, you know, it'll be marked non-buildable on certain easements and right of way.
Right, just on those easements or right of ways though, not extra setback off of those.
Yeah,
You know,
and any
totally.
of these too, like if that presents a hardship, obviously they can get relief from the zoning hearing board, but.
Or even from the zoning officer if it's so obvious.
This is a SALDO, could
Oh.
we get it from the
Oh,
supervisor?
Well, they could get it from the supervisors as a waiver.
Yeah.
It's, you know, if there would be a hardship, but I think that's probably the idea is that if you have one of those items that there's at least some buffer from the building being there. I mean, I wasn't planning commission, but that's what I would think.
I think that's one thing we're looking at, because you're looking at, I know it sounds restricted, but you're looking at some big pole buildings and such, you know, that really could interfere with some of the purposes of those easements or restrictions.
So
But if they're not,
But if they're not,
then there's a workaround, a
Yes.
reasonable workaround to it.
yes, there is. And for the SALDO part of it, it's very simple. You just come to the board of supervisors for a waiver or, I forget.
Or it can be waiting. Yeah.
Planning, they could go to planning would recommend,
Yeah.
and then it would come before the board.
So I just want to be clear, this is only on subdivision plans, not for zoning, correct?
Yes, the waiver zoning for subdivision, zoning would require a hearing.
But I mean,
Zoning hearing board.
I'm asking more of, if somebody wanted to put an accessory building on their lot, and there's an existing utility, but there's, you know, on their current subdivision plan, it doesn't show a setback or anything like that, would this require them to now adhere to this though?
Well, if the definition is the same in.
In zoning.
In the
Mhm.
zoning hearing, then yeah, then they would need zoning relief. in that.
So now somebody's gonna have to pay $750 to get that relief. Or $850, I guess is the new one for the zoning hearing board.
Well, and so that's the compromise that had to be made, because again, we're trying to accommodate folks for building in front. But there is, you know, and John, you understand that is part of the process. And sometimes the zoning hearing is required. There's not a clean, unfortunately, easy way, so.
Right, but I'll go back to my comment that I had was, once again, this township is taking buildable land, what was buildable, that they didn't get compensated for by easements or anything like that. You know, easements like utilities pay you to have an easement across your property.
I'm sorry, the township is taking?
Well, you requiring them to build back even further than that easement, you're in essence, not allowing them to build in that property, so that means they lost the ability to build in that area.
Well, currently,
Without
they're not allowed to
compensation.
build in the front yard. You know,
Right.
so are we taking their property from them? No, I mean, it's,
Well, what easements would you be talking about? I mean, most people when they, if it's a new subdivision, the easements are identified. Most people would know, where there are easements right now. You're not gonna build on top of an easement. If there's a structure that is already closer than what the setbacks indicate now, they would be a non-conforming use, they would be allowed to exist. So I'm wondering like what type of easements would be out there that, might with the application of these definitions prevent somebody. Like I could see like a stream bed, there's probably gonna be a requirement not to, build, within a certain distance, from a stream anyway. But I'm wondering like what kind of easement, like for instance, if it's a shared driveway easement, yeah, there's a setback from that, if it's, I don't know where there would be, stormwater easements other than in new developments that have, that are coming in right now. I don't know what type of easements would be out there. They would have to be a recorded easement.
Right, like water lines or something.
But what,
Oh, a water line, the water utility,
yeah, utility like that, but
like that runs through somebody's backyard. I know, it comes across, Mill Road area to Lamb's Gap. So that's why I'm saying, now they can't, not only can they not build an easement, which they shouldn't have been anyway, but now they even have more restrictive that they can't build in that area either, in the easement, in the setback area now.
yeah.
So,
I mean, a lot of those easements though do have, I know like a lot of the sewer easements, and that's different from the water easements, might say like 20 feet on each side, in order to get equipment in there and be able to, replace them. It's probably, with the setbacks that they have now, probably consistent with what an easement would require. But, that's what it says. It basically says that the setbacks will be from those items listed.
Right.
Yeah.
to go along with your thing about, hey, if it's 20 feet, that's normally, the easement that they got was 20 feet from the said line or whatever it is. But then the building setback's off of that easement line, correct? Say if it's 20 feet left and right, now we have a setback even, off of that. That's what I'm trying to say is, property owners got paid, compensated for, say if it was 40 feet wide, they got paid for that. But now they can't even build outside of that. They'd have to be in past that setback line. So, anyway, just my comment is I'm
that's what it
not
was
liking
there. Yeah.
you're further back from that even. You're not from the center line of that utility. You're from the easement line of that utility. So that's just my comment.
Yeah.
Is I don't like that you're making it even more restrictive with that effort. Saying you're outside the easements. Okay. Zoning, once again, it's the same definition about the setback, building setback, so I won't even comment on that. So if you go, I see there's multiple times where you add the line about accessory buildings are permitted in the front yard if the lot is of sufficient depth, that the accessory building is no closer than 150 feet from the right-of-way line. That was added to multiple locations. But in Article 5, which is the Ag District, which is Section 360-29 Yard Regulations, on page 40, letter F was added, which has that. But then it also adds temporary seasonal buildings explicitly used for the sale or of produce or similar agricultural products are not subject to the setback requirements. So my comment / question, I guess, is what is considered a temporary seasonal building? As noted in the exception, so you think you'd be pretty definitive, because I can't find anything like that in the definitions. And to go with that, does temporary mean it's removed when not in season for agricultural products? And what is an agricultural product considered? You know, is it selling shovels and farm equipment, or only produce, because it says produce or the like? And I'm wondering, why is it in the ag district only and not in other districts? And yes, this is my last question, so.
What's he talking about?
Oh,
The zoning.
the zoning changes.
Yeah, we can start with the supervisor.
I specifically remember, and there's several pages of comments here, this Perry County Planning Commission recommended that you make an exception for agriculture, because they're always looking out for the farmers. And that was their comment, and that's why that was inserted, because I was there when you guys saw that.
Is there a necessity to add that, the definition into it, or we cover it, because again, our planning commission was here for several hours, several evenings, passing through all this.
And if you notice, throughout the ordinances, not just with these changes, they're protecting the farmers and agriculture. That's just been, when it comes down through Tri-County, Perry County, I hear it all the time, we have sessions of it, protecting agriculture and the farms.
The county had no issue with how we.
No, actually, I think they took the.
It's from them, I'm pretty sure, yeah.
Yeah, ultimately, that definition, if it's not defined, the case law says that you go to, dictionary or common definitions of a certain word. So, in a lot of cases, if there's not a definition, somebody comes in with a building like that, it's just going to be, it'll be, whatever that person indicates the building is and the township indicates the definition is, and there's going to be some resolve that way. And like I said, it's usually, temporary will be as defined. If it's not defined in the ordinance by, general, Webster's dictionary definition of temporary, and same with agricultural. So, if it's just limited to produce, produce would be, food items, farm like food items, I would think. So I think there's going to be, some limit based upon the words under the common definition would be. So.
It says produce or similar agricultural products.
Yeah.
So I would say produce in the summertime
Hay,
and Christmas trees in the wintertime.
hay, straw,
Well, yeah.
kind of thing.
Can I get
Okay, Charlie, yes.
John. Charlie Cumble, 3404 Val.
Thank you, Charlie.
Would that be
considered like farm equipment storage too?
No, I wouldn't think so,
Why not, Sean?
because it says produce or other agricultural product.
Agricultural tractor.
A baler is not an agricultural product,
How, you, really?
right? It's not. It's an agricultural piece of equipment, but it's not an agricultural product. It's
Yeah,
not-
I would agree with that. I don't even think that's a stretch. I mean, I think that's common sense. That, yeah, that's, it is a piece of equipment. I think we would agree. You think of a product as, here's corn, tomatoes, something like that. Okay, but a
Product,
combine is not a product.
product is what they sell on the Chicago Board of Trade, not.
But
So I couldn't put a lean-to up down there, three-sided, facing side open to put 3 tractors. That's what you're telling me.
it would be an accessory.
Yeah, I mean, I don't think that would be temporary either. I mean, it's.
What if you put a hoop building up and you set it up on Georgia barriers, it's not touching the ground?
How would that be temporary though? I mean, the person typically put that temporary.
It could be moved anytime. I'm just putting it out there. I mean, there's already a couple in the valley. There's already a couple buildings, those hoop back jobs that
Oh, yeah.
20-some years ago, it was like, oh yeah, okay, yeah, you can put one of them up. That was temporary too, and it's still in the township. I just don't think we're playing fair here.
Well, I think we're trying to play fair without also having our ordinance and zoning being something that is just not navigable. So try to cover as much as you can without having a 3-page definition of what's a product. And I don't mean that to be, slightly a comment. I understand where you're coming from.
I just don't understand why produce would fall under but equipment would. You're using that equipment to produce your produce.
I don't know if there's further answer to that or not.
I think a lot of agricultural communities do have, they want to encourage, farmers to be able to sell their products, on their property. So, they would encourage, sort of this type of facility to, sell, their corn, their other food products, honey,
That's
stuff like
great.
that.
That's not what I'm
Well,
asking about.
I know what you're saying, but it doesn't, I mean, that's, I think, a separate step. Like if, I think the storage of equipment would be an accessory building, like an outbuilding to a, and then,
So it's a
it would have to
definition thing.
comply. It would have to comply. Yeah, I don't think it's the same thing as a building to sell produce. You know what I mean?
Are you considering a use for the building? Because we have plenty of buildings that were intended for agricultural use and then converted to just storage buildings. So that's why I always question use being the reason for things. Anyway, I will come back to my comment though. There was an additional thing, the solicitor did say about if there wasn't a definition of the temporary seasonal building, there wasn't a defined temporary seasonal building definition. But I'm sure if you have the ordinance up there, if you want to look in Article 7, which is Section 360-48, permitted uses, that's in the residential section. It talks about a temporary roadside stand. I would think that would be very similar. And that itself talks about the stand shall be removed during seasons when such product is not being offered for sale. In no case shall such stand remain where placed longer than for a period of 6 months in any 1 year, and such stand shall be placed not closer than 25 feet from any lot line. So I'm wondering,
From any what?
any lot line. So I mean, what's the difference between somebody having it on a residence and then a farmer having it? I would think the definitions should almost be the same. And when not in use, it gets moved. If it's considered temporary, why is it there all year long?
I don't have any comments about it.
Yeah, I'm not sure what the planning commission is on.
The intent was to protect the farmers and their right to sell their, like you were saying, sell their product at a roadside stand and at a community benefits also. Roadside benefits stand, however you want to call it, but it's agriculture. It's not somebody having a yard sale and putting a roadside stand out there. It was agriculture project. That's what I understood. That's what I sat there.
And I'm just questioning what is considered temporary. Is that it has to be moved then during non-season times? Or just as closed and now it's still sitting there?
Currently, I don't know that we have that defined, temporary, like we do. I don't know that we necessarily need to, want to, like, advice on that, or is that, where some flexibility is needed?
Well, I mean, I think it depends on, you know, the planning commission and what they would see as, these type of structures. They're going to be similar to, you know, the definition Mr. Schulze indicated, and it would be similar to that if it's something that, you know, the stand stays up, but they can't use it. You know, I'm not sure if the, you know, the discussion would be, I mean, it's something that, you know, at this point in time, you know, you have what you have here. I mean, you could always go back and define it more, or, you know, handle them on a case-by-case basis as they come, as long as you're consistent, you know, across the board, presenting hearing board and, you know, with regard to the SALDO, you have to be consistent with everybody that comes in front of you.
Or could the zoning officer would be, I mean, if they're coming for a permit for that, he would be the one, the first.
Yeah, he would make the first determination on whether it fits the definition. If he says it fits the definition, then, you know, he'll issue a, you know, permit. If he doesn't, then, you know, in the zoning hearing board, in the case of the SALDO, the supervisor will make that. Well, if it's, that's going to be most of the zoning issue. Because they're not going to come on a SALDO issue. But it would be, you know, it would be his own.
Okay. Other comments?
Yeah, I want to do this one more time. So in other words, like Schulze was saying, it's temporary. It would have to be removed in the fall. How much further is it gonna go? Like Brad, is he gonna have to put the parking lot out front somewhere, step back off of that? It's, some of this stuff is getting out of hand. I mean, I grant I haven't been to a lot of these meetings lately, but it looks like I should. I mean, I've been out here 65 years and it's like,
Well, but.
Wow.
No, but this is an exception. I mean, so what they're saying is, there's rules and regulations for these type of structures, but there's an exception to allow, you know, for farming products, these temporary stands that don't have to abide by, you know, the normal regulations because they're temporary and they're only selling products that are agricultural products. So there's the normal, you know, the zoning requirements, but then this is an exception, so it's lessening.
But what I'm getting at is, yeah, it's seasonal, but
But it's lessening.
further down the road, where is it gonna go? Is he gonna have to put a 20-foot right of way in for parking lot, or where does it end?
Can I ask a question?
Well, but the thing is
Are we advocating that, his son's, vegetable and fruit stand is in the wrong place and it should be farther back and so on and so forth? Is that what we're talking about here?
We're not talking about any of that because that's already existing, so you're not changing any of that.
That's good. 'Cause it would piss me off if it did. Thank you very much.
no, it's being less restrictive. It's saying that, there's these zoning requirements that are in place, but then this new addition is saying that these type of temporary structures are not gonna have to adhere to these requirements because they're temporary and they're selling products, farm products, agricultural products. So it's pulling stuff out and making it less restrictive for those type of uses, not more. It's less.
Other comments?
That's good.
So, as I said earlier, the planning commission, Sean's a member,
Thank you very much.
has put many hours into making these revisions and these improvements, which again, the desire is to provide people more flexibility and at the same time address some issues that neighboring properties, somebody does something, causes a problem for a neighboring property. So to try to address that, but in the end, this area is to give more flexibility to the residents.
And guidance.
And guidance, thank you, yeah, because it is tough. If it's tough to know exactly black and white, then, so they were trying to improve that, and they were here many hours, many evenings, and those were public meetings. So thanks very much to the planning commission members, because they do a lot of work, and they're not paid, in case folks don't know, they're totally volunteer. Thank you to them.
They're highly qualified.
And they were high, we hear that often, we have the highest qualifications of commission ground, so we're very, very blessed in that way. So with that, I'll make a motion to adjourn. Second?
I'll second.
Sean, second, all in favor? Meeting is adjourned. Thank you, folks. Now,